This case is sealed. Tyler is the administrator of WisNet and the e-filing, the entire e-filing system. Tyler said you have to go to the court, physically go to the court if Department W cannot help you so that you can gain access to the...
Case number D19-C, the matter of versus. Can everybody please state their appearances for the record, starting with the plaintiff?
Good morning, good afternoon, sorry, Judge. Robert Blau, Nevada Defense Group, bar number 10857, appearing on behalf of the plaintiff, who, as you can see, is not present. Congratulations on your appointment, by the way.
Thank you, sir. Nice to meet you.
You too.
And for the defendant?
As pro se.
All right, Mr. Nice to meet you.
Thank you.
One of the questions I had after reviewing this was whether or not Mr. had been served and was aware of this hearing, but I believe someone had called this morning, and I don't know if everybody knew that this was even on for hearing today. So my understanding is this is a defendant's motion for proposed order for appearance and examination of a judgment debtor for is asking for findings of fact and conclusions of law with regards to obtaining discovery and execution of a judgment. Mr. Blau, if you go ahead, this is your motion.
May I?
No, it's not my
sorry.
motion.
Oh, I apologize. Defendant's motion. I got it backwards. I apologize.
That's okay.
This is your motion. The one thing I did have a question on, I didn't get a copy of the judgment. I didn't see it attached anywhere, and I didn't actually get a copy of what judgment you're talking about, whether or not it's been reduced to judgment, and so on and so forth. So it's your motion. Why don't you go ahead and address that when you argue your motion, if you would.
Okay. If you could look, Judge, back in December 21 of 2022, there was a hearing where the Judge Rochelo had ordered that she was going to reduce that to judgment collectible by any legal means, and then that was followed up on a written order submitted on February 9.
Hold on one second, because I don't normally go hunting around for this stuff, so it's usually easier if you attach it or something. So let me see which. A lot of times when you get into these cases, you have 400 entries on my end.
Oh.
For me to find what you're talking about is really usually pretty difficult, so it's best to attach it to your motion. So what date are you referring to?
It's February 9th of 2023. That was when the written order was submitted, as well as, I believe, the notice of entry of order. And I apologize, Judge. I've been trained by Judge Rochelo pursuant to the new rules effective June that I'm not supposed to submit any pleadings of record in a family court division as reference. It's a new rule. A new rule came out in June of last year where I'm not allowed to attach an order as a reference for your convenience. I apologize, but he's already nailed me in that court about attaching an order as a reference, and so I apologize, but maybe the rules are different for when we submit things to the commissioner. I'm not sure, but
the biggest problem is that I didn't know what you're talking about. So
okay.
You got you can cut and paste part of it into your motion if you had to. But let me just take a look here real quick and read this order if you don't mind.
Sure.
So there's a lot of stuff in here I need to be concerned with. Where in here is your judgment? So to $800 reduced to judgment. What
Correct.
else?
That was it as far as that particular judgment goes. There's another judgment that I know it's not applicable to this particular motion, but the judge also awarded a child support arrears judgment effective Sunday, the 16th of July. But
okay, hold on. So in your motion, there's reference to $800. This is on page 3, $800.
Correct.
And that's the amount of judgment that I just looked at. It says currently there exists a submitted schedule of arrears with interest before this court in the amount of $12,000. And then it says a second notice of intent for $15,000. This is not a judgment debtor for that amount. This is a judgment debtor for $800.
Well, now it's applicable to both because the judge just awarded the judgment debtor amount on the $15,345.32 effective July
Where?
16th.
Hold on, Mr. Blau, hold on.
That was
Mr.
as a
Yes.
notice of entry of order yesterday.
Okay. We go back to the original.
It's quite a long register of actions in this case.
Okay, so now I got two judgments. So, what is it that you're requesting as far as relief?
Well, if I could give Your Honor just a little bit of background, there's been an exchange of multiple different counsels on this case. It was Eric Ferran when that order was written originally for the reduction for the $800 to be reduced to judgment, and then there was Kara Stevenson that was on the case, and she and I had multiple meet and confers regarding the collection of these judgments, and I was going to serve, well, actually, I'd sent to her different discovery requests as far as interrogatories and production of documents go. That culminated into kind of a little bit of she had a challenge with her client. She said she wasn't just going to participate in the discovery. So there was this discussion of Rule 69 where I'm allowed to seek collection on a judgment, but there's also this other discussion that family litigants can't engage in post-judgment discovery. So that's why I originally put this before Judge Rocheleau, seeking conclusions and facts of law, so that Ms. Stevenson at the time, Attorney Stevenson, could admonish her client to participate in the discovery that I would be propounding upon her. Well, that wasn't going to happen, so that's why, if you notice, I filed this motion in April 22nd, and there was also attached an order with that for the debtor examination to take place in front of the court, as well as some discovery requests propounded. I followed up with a service of those written, instead of just email, this time I served it on record with the court, but I served it through the e-file service to Ms. Stevenson, I believe is April 30th. To this date, I still have not received anything. And I know Mr. Blau is new on the case. He called and left a message for me somewhere last month, I don't know the exact date, requesting that I give him until the 10th of July. And I did call his office back to have a discussion with him. I never got a return phone call, but I still have not filed a motion to compel, even though if you look on the case, I've filed multiple requests for email, as well as I filed a notice that I'm going to file a motion to compel. But I'd like to avoid all that. And so,
Okay, so let me, it was a very simple question. What exactly relief are you looking for? Do you have discovery that's outstanding that you
correct.
did?
Yes.
Okay, are you entitled to discovery based upon NRCP 16.21?
I believe I am, because as a judgment debtor, Rule 69 allows me to collect on the judgment.
Well, there's a specific rule in family court. Well, I don't know that I need to do all this, but
In the judgment,
I'm looking at post-judgment discovery in family law. Now, whether or not you're entitled to a judgment debtor exam is different than discovery. You know that, right?
well, I'm allowed to ask according. If you read the pleading, if you scroll down, I actually
I read the
attached
pleading.
not only the NRS 21.270 as well as the NRS 21.310, but I also gave Your Honor some case law regarding that. Where, if you read that case law, there was somebody that was dodging post-judgment discovery, and it resulted actually in that person being punished, contemptible, by going to jail. But ultimately, it was ruled in that higher court that
It's a really simple question. What relief are you asking for me?
for an order that she be ordered to appear for a debtor examination.
Okay. All right.
And then
so we're not
also-
dealing with discovery then, okay, right? So we're not
That-
dealing with discovery then.
Yes, we're also dealing with discovery as well because also to answer discovery requests, to order her, I think if you can order her to participate in discovery, then Mr. Blau will be able to compel his client to answer the discovery request that I propounded upon her.
Do you have a evidentiary hearing coming up?
No.
Has there been an order from a judge allowing for discovery, post-judgment discovery?
No, that was what I was requesting in this motion. And then Judge Rocheleau said that it had to come to you first.
Okay. So here's my concern on a judgment debtor exam for $15,000 plus. You just got the order yesterday. What have you done to try to
I had the $800 order back in February.
What have you done to try to get the $15,000 as of yesterday?
Well, it was just yesterday awarded and entered, but the $800 one I've also submitted for writs, and we have currently filed with the Henderson Constable selection on a writ for execution.
Okay.
And that's should be part of the record. I don't know if you can see that in there, but that was filed for the writ of execution. I'd have to look back, but I believe that was somewhere back in April or May as well for the $800. We have two separate judgments. We have the one that was issued. Okay.
I got them printed now. I now see them. Yep.
Okay. And
actually, I needed the date on the first one again.
February 9th?
February 9th. That was the date of the entry of order?
Correct.
Okay. Hang on a second. I need to get back in there. February 9th. I can just do it later.
Okay.
That was 23?
Yes.
Okay, Mr. Blau. Anything else, Mr.?
No, other than I just want to make it a matter of record that there was no opposition filed on this. Originally, when I had meet and confers with Attorney Stevenson, she told me that everything I was doing was meritorious and she wasn't going to submit an opposition. She also indicated that in her filing that she placed before the court for a motion to withdraw as counsel. And so there's no written opposition on the case, and I just want that as a matter of record.
Okay. Mr. Blau, when did you become involved in the case?
Thank you, Your Honor. We filed a notice of appearance in this case, I believe, on June 21st or 20th. This case is sealed, and I'd like to make a brief record on that. When we got into this case, we contacted Judge Rocheleau, Department W, and attempted to gain access. Judge Rochelou's clerk, Monique Thompson, gave us access, but Tyler did not. We never were able to get into the case to see the actual register. Tyler is the administrator of WisNet and the e-filing, the entire e-filing system. Excuse me. Thereafter, they said to us, Tyler said, you have to go to the court, physically go to the court if Department W cannot help you so that you can gain access to the Register of Actions, which, as you can see, and as I commented earlier, is quite long and, quite frankly, quite convoluted. To make a long story short, we had to file under a new email to gain access to the Register of Action in this case. We obtained the Register of Action, access to the register this morning. This morning is when we got the approval. That, by the way, is when I found out about this hearing. Otherwise, Your Honor, I certainly would have been dressed appropriately. So I have to apologize for that.
I didn't even notice, but that's okay.
Okay. As soon as I did see what had happened here, I tried to find that motion to compel. I did try to find the motion in the Register of Actions wherein the defendant sought his $800. I did see an oblique reference in April in a minute order issued on April 27th by Judge Rocheleau, saying that it must first be heard by the Discovery Commissioner pursuant to EDCR 5.42, and she says concerned discovery issues, but there's no definition of what those issues are in that. So I remain unsure of what's happening. I do know that this motion, as Mr. admitted, this entire examination and this motion is evidently for an $800 judgment. $800. I did see yesterday that Judge Rocheleau indeed did just reduce, based on his schedule of arrears, did reduce his child support arrears to judgment. I do see that. That was entered. We, for the record, we will in all probability, I realize there's no stay on that, but will in all probability be filing some sort of objection or motion for reconsideration on that. I will say also, as long as I'm making that record, that indeed Mr. reference Ms. Paul's, my client's prior attorney, Kira Stevenson. We've been reaching out to Ms. Stevenson since we got on this case for a copy of her file or for her to communicate with us so that I, in fact, could see what efforts have been made to comply with discovery. Even though there's no motion to compel, I wanted to see where that was. To date, Ms. Stevenson has not responded to us, and I don't have her file yet. So I did want to come on today to appear on my client's behalf. I will talk to my client. I was not aware of that February judgment, and I just became aware. And I do believe Judge Rocheleau on her own entered the order from yesterday, so I do believe that's an effective order now. I would, quite frankly, I like the sentiment of Mr. that he'd like to avoid filing a motion to compel. I, too, had my questions about whether or not discovery was even appropriate and allowed at this point. There is no evidentiary hearing. There is no custody motion pending as far as I am concerned or aware of. So I'm going to reserve. I have not looked at that question well enough yet. That is something that I was thinking of. My thought, Your Honor, without attempting to delay this any further, is I would ask the court for a 2-week continuance to allow me to understand what's happening, perhaps to reach out under EDCR, used to be 234, I think it's 5502, and do a meet and confer. I haven't gotten
5501.
5501, no, I think it's 5502, actually. For meet and confer, which used to be 234, of course.
It is 234 in civil.
Right.
It is 55, according to my cheat sheet,
Yep.
5501, but I'm almost positive.
5501 is just, that's a request to
5.501 in the 2023 version says requirement to attempt to resolve.
Right.
So that looks like it's the right one.
I think there's a specific one to discovery for
That's,
meet and confers. Might be 5502. Now I'll have to go look. I'll wait for the court.
And if I could just have an answer.
It doesn't matter. The point is there's a requirement for meet and confers. Just a minute, Mr. Doesn't seem to be finished yet, so we're going to wait till he's done. And
So I haven't gotten that. We may well attempt to comply. I have not really looked at obviously, if they were served in April, probably the objections are waived at this point. If discovery is allowed, that is one thing I would like to look at, as the court said. I would also, rather than go through an examination of a judgment debtor, although the court said that that's not really applicable here, I think, I'm paraphrasing, of course, I would like an opportunity.
What court said? You thought that I said that?
I
don't know why.
I think you drew a distinction between examination and discovery. I'll leave it at that. It might well be appropriate in this case. I haven't read everything that's been filed in this case, but I'd like an opportunity to talk about complying voluntarily with an $800 judgment prior to coming back. That might be what he's looking for. Obviously, a child support order is going to have its own enforcement mechanisms and heft to it, if I can use that word, for child support arrears. I'd like an opportunity to talk with her, possibly to provide him with some discovery, unless I need to file If the court would indulge, I'd like to perhaps just review whether or not discovery is in fact allowed and open at this point. If it is, I'd like an opportunity to do a meet and confer and try to figure out if we can comply with his request voluntarily.
Well, all of that, the challenge is all of this has already taken place with two other prior counsels. And so I don't know where the rules permit that a person can just change attorneys over every 2 months and then just dodge discovery. If you look at the Rule 69, it allows...
My problem, Mr. I'm not sure discovery should be warranted at this point. You have a judgment. I think that potentially the mechanism is for judgment debtor exam, but I'm not sure how that conflicts with Rule 16.21 because there's been no judge that's ordered discovery. I can't order discovery. You know that, right?
I understand that. You resolve discovery issues, but may I refer Your Honor to page...
I've read your motion. It refers to a lot of federal law that is not binding on me.
But if that federal case was here in Nevada...
It doesn't matter. It's not binding on me. Federal law is not binding on state statutes.
I understand that, but it allows for a person...
Persuasive, but it's not actually binding on me.
But if the judge ordered that I'm able to collect by any legal means, and that's written in the order, then that allows me to apply Rule 69 in collecting on that debt, which opens the mechanism for seeking discovery.
So you have a problem here. You're referring to federal rules. Federal rules, I can tell you, there are no federal family law cases.
But there's
They don't
NRCP
Okay.
69 as well.
And then it's also NRCP 69, but you have NRCP 16.21, which specifically is addressing post-judgment discovery in family law cases.
In civil, actually, Judge, 16.1. 16.2 is family.
I said 16.21.
Thank you. Sorry.
Talks about post-judgment family law cases, which the federal court has zero to do with. Okay.
Well, I understand that.
So
I guess the context is the federal law allows me to pursue collection under federal rules or local rules. That's what for when it comes to collecting on a judgment.
I'm not convinced of that, but that's for another day.
I can
The
read
point
it.
is, I can read it.
Okay.
I've read it. And I'm telling you that NRCP 69 has its own mechanism for a judgment debtor exam. I'm not arguing with you on that. However, my problem is that that's in conflict with Rule 16.21, whether or not you're allowed discovery and whether or not you're allowed a judgment debtor exam. I think those things are two different items. Regardless of that, do you have any opposition to giving him 2 weeks to get involved, considering the fact that the case was sealed and on his representation, he just received this information?
Well, here's the challenge. I sent him via email. Well, actually, I sent him email requesting on another matter to meet and confer. I've never received any kind of reply back to that. And I specifically e-filed on record with the court the letter that I sent to him, which had the discovery requests attached to it. So it's not like he hasn't known about this, like he represents to the court. It's written and it's trackable that he has access. Furthermore, I followed up with Kiara Stevenson. She said she emailed to his office the entire file on the 27th of June.
So you've had this thing filed since April.
Correct.
What would be the harm in waiting another few weeks?
Well, because his client is in the habit of dodging all this so that she can move assets around. She's already done that. We're litigating that in family court on a separate matter. She's in the process. Here's my challenge. I've got Quadro Masters with the Willick Group preparing a Quadro for her NV PERS. Okay? And in order for me to move fast on this before she actually takes those in the way of a refund, because she's got probably over $20,000 in her NV PERS, If she takes it as a refund, she'll be vested and she'll get all that, and then it's going to effectively eliminate my ability to collect on the debt.
$800.
Right now, all the other avenues that I've pursued, she doesn't have, as far as I can see, she doesn't have distinguishable assets that I can go and get. So the only way to really do this is to kind of hurry, because I can almost predict for the court that she's going to move money around. She's going to do whatever she can to avoid collection on the larger judgment.
Okay, so here's what we're going to do. We're going to go ahead and continue this matter for 2 weeks. I'm going to invite a opposition, but more importantly, I'm going to invite some meet and confer. Whether or not we're dealing with an $800 debt, or whether or not we're now dealing with a second $15,000 arrearages. And if you're asking for a judgment debtor on that or not, I was a little confused in the motion about whether or not it was or not. It seemed to me that this was only for the $800. The $15,000 was a arrearages. So there are other mechanisms for collection on that rather than a judgment debtor exam. And if we're talking about proportionality for an $800 judgment, this may be a little overkill. Especially if she's now...
But I did indicate that it was a pending judgment waiting for the judge to sign, which she did sign. So
you can't get a judgment debtor exam on something that's not actually a judgment yet, and the motion didn't have the order attached, and it was just submitted yesterday. So there may be another mechanism for you to resolve this. If not, I'll see you in 2 weeks, and we can talk about it then. But in the meantime, Mr. Blau, that'll give you time to have them reconsider that other judgment. It'll give you time to get involved in this manner. I do believe that a judgment debtor exam is probably appropriate on the $800. I'm not so convinced on the arrearages at this point. And I'm not convinced that discovery is open. So I want some more briefing on that issue. I want to hear an opposition, and then Mr. have the opportunity to respond to the opposition. And I'm going to set this for 2 weeks to make, the opposition's due in 7 days. And then you submit your reply brief at least 24 hours in advance of the hearing for the 2 week continued hearing. But I really want some briefing on whether or not discovery should be opened pursuant to 16.21.
Will do. So my opposition will be in by the 26th, close of business, and I will brief those issues. You are not ordering a judgment debtor examination today. You are going
I'm continuing that.
Very good.
I'm continuing that for a couple of weeks. Is there one already set?
No.
Okay.
All right.
So, so you got 7 days to get an opposition if you want to. You may not want to. You may want to try to resolve this on your own. And then another 7 days we'll have the hearing. You're invited, Mr. to file a reply brief if you choose to on the opposition. Just make sure it's before the hearing, okay? And make sure it's served on all the parties. I'm just continuing the matter. I'm not making a decision on it yet. I need to, I would like to hear a little bit more about whether or not, first of all, Mr. Blau can get you your $800, but also whether or not we can come up with a different mechanism other than a judgment debtor exam for the $15,000 arrearages, and most importantly, whether or not discovery should be opened or not, and whether or not I'm going to recommend that Judge Rocheleau do that or not.
And you are ordering a meet and confer.
And I'm ordering that you meet and confer pursuant to, I thought it was 5.501. I still think it is, but if I'm wrong, then you'll correct me later on, I guess.
I will.
But
I start all my letters with 5.501. That's how I start my letters, is with 5.501. So.
Okay, well, try picking up the phone sometime too. That sometimes helps.
I did. I've called his office.
Can I ask for your, because I don't have your email. Can you state your email for the record, sir?
Mine?
Yes.
I've sent you emails direct, okay? But yes,
That's interesting.
at gmail.com, and it's at the front of all my pleadings, all my briefs, all my paperwork.
Okay, I'm just
It's a
seeing
matter of
those
record
today
with the
for the
court.
first time. Okay, I have it then. All right.
And his phone number is also in the court record.
Yes.
And you have Mr. Blau's correct email address?
I do.
It's rblau at defendingnevada.com.
Correct.
Okay, so I'm also asking that you include in your opposition and/or reply brief your attempts to continue to resolve this. Okay.
Yes.
Absolutely.
All right. So, Madam Clerk, am I on calendar for 2 weeks from today?
Yes, Judge. I want to say August 2nd at 1 p.m.
All right. Let's make it 1:30 again. Okay.
August 2nd. Let me just look at that if I may. Okay.
Good.
That works.
I'm glad you're free.
Thank
See
you.
y'all again in a couple weeks. Please take this opportunity to try to work it out and see if we can narrow the issues down for me. All right.
Thank you.
Thank you.
Thank you. All
Thank
right,
you, Judge.
Bye-bye.
Madam Clerk, I'll stay on for a minute. Okay.
Okay, Judge.
Did you have any questions for me?